Zena Yesler. Here. Lottie Cootie. Lottie Cootie. Okay, I heard you. Andrea Scraper.
Here.
Ella Coleman.
Here.
Shirley Watkins.
Here.
Natalie Harjo.
Here.
Tiffany Thomas.
Here.
Catherine McCoy.
Here.
Charlie Hill.
Here.
Tiffany Cully.
Here.
Danita Harjo.
Here.
Willis Dethridge.
Here.
Desiree Emerton. Desiree Emerton. I have a count of 25 present, 3 absent.
With a count of 25 present and 3 absent, I declare that we have a quorum and we are now in session. We're going to go to prayer, and I'll go ahead and lead us in prayer this morning. This is the first meeting of the new year, 2022. So you can reverently bow your head, or you can stand, either way. Great and awesome God, as we come to you this day, creator of all heaven and earth, we come with grateful hearts, knowing that the challenges that the Seminole Nation has faced over the course of the last few years with the pandemic raging, you have still been with us and with the families, even though many have succumbed to that very thing. Lord, we do thank you for your presence in the people's lives and with this General Council and with the executive leadership. We ask that your presence be with us this morning in leading and guiding us in all wisdom and in knowledge and in common courtesies to one another as leaders of this nation. We pray for all those who are overseas and in different areas that are serving in different capacities for the sake of the United States of America and for the Seminole Nation. We also pray for those that are home bound and can't get out at this moment. We pray for those in the nursing homes, and we continue to ask that your continual blessings be upon the Seminole Nation of Oklahoma. And as we conduct this meeting today, we ask for your leadership and your guidance. We pray in thy name. Amen. Thank you. We had some council representatives that we're going to continue to go by the agenda unless some representatives have thought that we might could go out of the order of the agenda and go straight to the RFPs for the Attorney General with those interviews. And if that's what the council wants to do, this would be the time to do that, and then we can come back to the actual order of the agenda.
Chair, I make that motion we go out of order and do the RFPs first.
Okay.
This is Karen.
There's a request by Representative Fulbright to go out of the order of the agenda and address the request for proposals of the Attorney General at this time, and then return back to the order of the agenda after those interviews are taken. Is there anyone that opposes to that? If there's anyone that opposes to that, then we'll take it to a vote. But if not, then we'll go ahead and consider that we will go out of order of the agenda and go down to the first item on new business, which is the law firms responding to the Attorney General request for proposal. And I take it there's no opposition to that. So by consensus, we'll go in that direction. Any objections? Okay, I'm not sure exactly who's back there, and for the council that's online, the firms are in a separate room than in the council house. BCR was gracious enough to have them be seated back in their offices, and as they are ready to interview, they will be called on the council floor. Which firm do we have back there? I know first is actually supposed to be Shield Law Group. Shield Law? We're ready for them then. They'll be given a presentation before the council today. Allow them to give their presentation, and then we can hold questions toward the end of their presentation, or if it requires you have a question during their presentation, that will be fine as well. You that are virtually, just kind of wave your hand. Some of you are not showing your image, or say chair. If you say chair, then I'll address you and acknowledge you. Is there a way that they can actually face the council who are present, or is it going to create an issue with the camera? Okay, that'll work. They can stand in front of the tables. Thank you for being here today. These are members of the Shield Law Group who presented and answered the request for proposal. So if you can come up and stand in front of this table, there's a cordless mic here, and then you can start your presentation before the General Counsel of the Seminole Nation. If you want to stand on this side, that way the camera can catch you, and then you won't have your back turned towards the council that is present. I do want you to know that we are doing what we call a hybrid meeting, which means that there are many council representatives with us today virtually, so they can see you, they can hear you, they can correspond with you as far as questions. And then we have some that are present and live. So we have 25 council representatives present in this meeting, either virtually or in person, okay? So go ahead and take it and introduce yourself. It's good to have you here today.
Can you all hear me through this mask? Well, first of all, thank you, Chief and Assistant Chief and Council, for giving us the opportunity to be here today. It's an honor and a privilege. I am Amanda Proctor. I am an Osage Indian. Shield Law Group is an Indian-owned entity. We have been in operation since 2010. I have been practicing law for much longer than that. I've been practicing law for almost 20 years. And prior to obtaining my law degree, I was a tribal housing director. So I went to law school having served as a director of housing for several tribes, including the Otoe-Missouri tribe and the Pokagon Band of Potawatomi Indians. I have a very long connection with this community. My best friend from childhood is a member of the Seminole Nation and very culturally active. Through her, I met the man who would become my husband, who is also Seminole. My children are Seminole. That's my mother-in-law sitting back there, Miss Eileen Miller, so I appreciate her being here. Again, my children are Seminole. My son works for me and serves as my assistant and my office manager, so he is a member of the tribe. I also have with me Sarah Schmoke. She is a lawyer who works with me. Sarah brings a very special skill set to the table. Sarah is not only a lawyer, but she is a certified public accountant. So with us, it's like you get lawyers, but you also get a little bit of Finley and Cook without the price tag. And Sarah comes in invaluably because she's very familiar with the IRS code, the Treasury code, and as you probably know, many of these new sources of funding that are coming into the tribe through the ARPA and the various acts that are gauged towards recovering from the COVID pandemic, Many of those programs are governed by the Treasury and by IRS regulations. So even people like me who've been swimming in this water for a long time with HUD rules and USDA rules and BIA rules, well, now we've got a bunch of new rules, and Sarah is invaluable at keeping up with all of those requirements. Also, as you probably realize, there's a lot of math that goes into this. When we are doing restructuring of big loans for casinos and for big development projects, there's a lot of math involved with that, and we have to make sure that the tribe is getting, the benefit of all of those calculations. When you do a cigarette compact, when you do a gaming compact, when you do a contract between a gaming vendor and the tribal enterprise, if you make a mistake when it comes to how those profits are allocated, or when it comes to the free play or those kinds of things, those mistakes can cost millions of dollars. So it's very nice to have someone with Sarah's accounting background and the right side of her brain functioning on all of its cylinders as part of our team. So I'll let Sarah say a few words as well.
First of all, thank you all for having us here today. We certainly appreciate it. As Amanda said, I'm a certified public accountant for about 19 years now. I went to law school in 2009, and I had the pleasure of meeting Amanda through some friends and working with her for the last 9 years. It's offered me a lot of opportunities to learn a lot about tribal entities and work on gaming compacts, housing. The biggest issue I honestly see in working with Amanda when I come into play is all of the reporting. And reporting with new gaming compacts. I think there's issues with sports gaming now, sports wagering, that's going to have a lot of reporting. These contracts that Governor Stitt is working on with tribes, and he's not using a uniform contract. He's doing it tribe by tribe, watching those percentages, because as Amanda says, that can cost you millions of dollars. There's audit requirements, there's a lot of rules and regulations with a lot of math, and so that is where I come in. I do have a good 20-year background doing the accounting. I do forensic accountings with Amanda for other tribes, just keeping up with the money. So we appreciate the opportunity to speak with you guys today.
And we didn't want to scare anybody by using that word forensic accounting, but we have had to do that for other clients, and we have had to sue various non-Indian people who have tried to take advantage of tribes, and we've done that successfully. We had one case where several $1 million were stolen, and we were able to recover some of that through litigation, as well as making referrals for prosecution to the feds and to the Securities Exchange Commission, which resulted in the prosecution and the return of some of those monies. So that's an unfortunate part of our practice. We don't like having to do that, but unfortunately it is something that we do encounter in Indian country. We also wanted to point out that we are involved in a lot of the federally funded programs. We have helped tribes become compliant where there were compliance deficiencies. We've helped tribes defend audits and administrative enforcement actions brought by various entities. We have a long history of that. We have probably worked for at least half the tribes in the state of Oklahoma at one point or another. Because I am a housing director, a lot of our core clients are tribal housing entities, so we've been involved in many development projects, apartment projects, low-income housing projects, rent-to-own. I have a client in the Tahlequah area who just opened a group living facility for elderly people and is looking to open another one. It's a very cutting-edge project. I also wanted to point out that we've got a couple members of our team who are not present today. One, Tylana Nofire, was an internal attorney for the Cherokee Nation Business Enterprises for many years. Her background is also in gaming. And I would be remiss not to mention Miss Patty Palmer Gezzi, who is part of our team and the senior member of the bar. And you will probably recognize her name from the McGirt litigation. She was the actual federal public defender who represented Jinxie McGirt in the underlying case. So she was his actual attorney who I consider to be the architect of the new landscape that we have now in the state of Oklahoma, and she is the leading authority on McGirt and McGirt-related issues, in my opinion, if there is one. Lawyers aren't allowed to claim any kind of expertise. Believe it or not, it's unethical, but to the extent that we can say that our practice emphasizes certain areas, that would certainly be one of them. So with that, we're happy to take any questions that the chief or the council may have.
I'm scanning the virtual council representatives and the in-house council representatives. Are there any questions at this time for the Shield Law Firm? Oh, we have one, Representative Petit.
I just had a question regarding a conflict of interest. How would y'all address that? If there were disputes between, say, members of the 5 civilized tribes?
Well, we try to avoid that to the greatest extent possible. And let me tell you what my personal philosophy is. My personal philosophy is that we're all on the same team. I had a councilman from another tribe ask me if I believed it was a conflict of interest for the same attorney to represent the chief of that tribe and to represent the casino of that tribe. And I said, no, we are all on the same team. The gaming enterprise, the council, the chief, the tax commission, the housing authority, all of those entities should be functioning for the best interest of the Seminole people. They should be. And when a tribe comes to me and says, hey, I don't like how my gaming commission is operating, or I don't like how my housing authority is operating, I do everything that I can to try to make peace and find the middle ground. Because what we refer to as intra-tribal litigation, which is one entity of a tribe versus another entity of a tribe, is the most costly, unproductive, dysfunctional type of litigation that there is. And even though I could personally become wealthy from those kind of disputes, I try to avoid them at all costs, and especially for me, as I said before, because my family is Seminole, and my children are Seminole, and my grandchildren and my great-grandchildren will be Seminole. And this is a legacy that I'm leaving for them. And I have to coexist with you all and my children for many, many decades. And I don't want to do anything to the detriment of the Seminole people. I want the Seminole people to progress for your sake and for their sake. Did that answer the question? Or as far as the 5 civilized tribes go, let me take another approach. I think that we have some common interests and some common issues with those tribes. Let me give you an example. Obviously, the McGirt litigation is on everyone's mind. That is going to be a big challenge moving forward, and I think that we have to consult with those tribes who have similarities to us, especially the other tribes that have the 1866 treaties, like the Cherokee Nation, for example. And we can't let the state of Oklahoma exploit any weaknesses that they may perceive. Because right now, Governor Stitt is on the attack. And his attack narrative is that these tribes are dysfunctional. And they can't provide equal protection to their own people, let alone the citizens at large of the state of Oklahoma. And we have to be just as aggressive as he is. We have to perceive every void. We have to fill every void with services, with laws, with resources, and cut him off at every pass. And it's going to take all of those tribes working together to do that. And so I don't see conflicts. I see room for collaboration and growth. I don't work for any of those other tribes. At the moment, I work for the Thaplaco tribal town, and I work for the United Kituwa Band of the Cherokee Nation. So I don't have any direct conflicts as far as any of the other 4 civilized tribes would be concerned. My loyalty would be to the Seminole Nation if there were to ever be any sort of antagonistic issue.
Okay, thank you. Representative Pittman, I seen earlier where you had raised your hand. Are you with us?
Yes, sir.
Okay.
Thank you,
You're
thank you, Mr.
recognized.
Chairman.
You're recognized at this time.
Thank you so much, Mr. Chairman. My question would simply be, what reporting system do you prefer? What reporting system would you implement for the Seminole Nation, since there's a variety of ways to report, and as opposed to reporting one tribe at a time, what system would you prefer that we use? Because my question is, would it cost us additional funds to implement a new system, or is there software that comes with it?
As far as the lawyers reporting to the governing body of the tribe, do you mean, or is that what you're asking?
I think she wants a clarification, Representative Pittman.
Okay, yes, the reporting system that you will be delivering information to the chief or to the council, so will it be electronic, or will it be just by you giving a written or oral report, so that we have an archive of the reports and can go back and look at those reports as you're reporting, whether it's for gaming or housing or anything else?
Well, we're happy to implement whatever sort of system suits the governing body of the tribe. I am available to be here for any and all of your meetings that you would want legal counsel present for. We would also give you monthly billing statements so that you would know how we spent our time. And we're very conservative with our billing. Again, I consider myself to be part of this community, and I don't want to take advantage of anyone. I don't want to walk into a wild onion dinner and have somebody, mean mugging me because I'm because I've, stolen the goods. So we will be very conservative, and we will give you the benefit of every doubt when it comes to billing. And if you would like to have a monthly written report from us in some form or fashion, we're happy to do that. If you would like for us to monitor, these cases like McGirt and the related cases and give you periodic reports, we are happy to do as much or as little as you desire for us to do. And then our bills to you would just be a function of how much work that we've done, bearing in mind that we will give you the benefit of every doubt.
And follow up, Mr. Chairman?
Yes.
Thank you so much for that report. My concern is we have special meetings and regular meetings, and sometimes our members who are not present may not have the minutes reflect the details. So I'm just as curious to know if you are planning to give us an Excel spreadsheet or something that addresses all the cases that you will have reviewed for that year or that quarter, so that we can go back and look at what you've done, just as opposed to receiving a monthly billing statement and not being able to go back and have something in our hand to review.
You're referring to more of a narrative of the
Yeah.
work being conducted by the Attorney General, and that should be something that's rather simple to do, because if whoever the Attorney General may be, they should have that scope of work for that invoice. And a lot of the narrative is on the invoice. I mean, it might be a condensed version of what they did for that charge, but they can expound on that so that we can have a running correspondence of the historical record of how we dealt on any particular subject matter that the nation may deal with through the course of time.
And we typically also ask the governing body of the tribe to instruct us regarding the protocol as to who we can and can't speak to. And typically there would be one or two designated people, be it the chief or the executive director of the tribe, who would give us our marching orders. That way we're not getting phone calls from people in different camps who may have different ideas as to the path forward. So we try to keep our communication very direct so that we don't, cause any chaos.
Is that more of a understanding there, Representative Pittman?
Yeah, that's perfect. I just wanted to know where the documents would be archived if there was a particular decision that had to be made, and we reviewed the invoices of the past, but it didn't tell us what the recommendations were or what the final decisions were on that issue. So I was just looking for a summary of those things, and if it's on the invoice, that's great, but just a summary of reporting the recommendations that could come from anything that we ask the council to make a decision on.
And we can also create a portal electronically, and we can upload documents to that portal, and then the governing body of the tribe would give access to that portal to whomever the governing body deems necessary to have it.
And we do have an existing tribal general council portal, so those things could be implemented there as well as to have a running chronological order to date to be placed in records management, so that administrations coming down the pipeline throughout our future can use those things as reference without the difficulty of trying to do the research.
Thank you. That's
Yeah.
what I'm asking for. Thank you.
Okay.
I didn't know we had a portal available, so that's perfect. Thank you.
We'll send you the connection to that portal, Secretary. Send that to Ms. Pittman if you would. She is a new
Okay.
council representative.
I believe I already sent that to her, but she may have not
Okay.
seen that email.
All right. Thank you.
Thank you.
Any other
Thank you.
questions for Shield Law? Okay.
Chair.
Oh, I see your hand there now. John Representative Narkemy.
Yes. My basic question is, I reviewed your proposal and your individual resumes of the lawyers involved. My question is, do any of you currently have are members of the bar of the Seminole Nation?
Oh, the Seminole Nation Tribal Court. No, I don't believe that we are. We certainly would intend to join the Bar Association of the Seminole Nation.
Okay.
Because I've got a new lawyer now that we're going through and making all of those connections.
Okay, thank you.
Representative Ocheezy-Ban.
I've got two questions. First is, your thoughts on the Seminole Nation getting sports betting and esports betting at the casinos? And the second question, your thoughts on, do you see anything that the Seminole Nation can do for the tribal members who have a good background, but the state marijuana card holder, it is making them unemployable on tribal lands because of their medical issues? It's a Seminole County problem, but it's also going through the Indian country as well.
As to the first question, the state code contains a model tribal state compact, which is the structure of the gaming compacts that all of the tribes have adopted. And that model compact in the code, unfortunately, does not allow for sports betting or event betting. So in order for the tribe to conduct that sort of operation, there would have to be a lobbying effort with the state legislature to make those accommodations. And you're probably aware that Governor Stitt had negotiated a couple of wild compacts with a couple of other tribes that subsequently were set aside in part for that reason, because they contained sports betting language that was not permissible under the law as it now stands. That's not to say that it can't happen, but if it were to happen by tribal ordinance without some sort of corresponding movement on the state side and with the model compact, then we would most certainly have a compliance problem. So that's something that has to be carefully approached, but certainly it's something that a lot of tribes are looking at, and that could be, you know, an economic windfall for the tribes that are able to make those connections, but it has to be done carefully. I defended, I think, the only two National Indian Gaming Commission enforcement actions that have recently been brought against tribes, and we defended both of those successfully and kept the tribe out of hot water with the National Indian Gaming Association. In fact, one tribe was never even formally cited, because when we realized what the issues were, we dealt with those issues at an informal level. So we certainly have experience dealing with the National Indian Gaming Commission and with the state regulatory agencies, and we would do everything in our power to make sure that the tribe didn't make any wrong moves in that regard, which isn't to say that we can't plan for something like that in the future. As far as the second question is concerned, you know, one of the problems with marijuana is that it's still illegal at the federal level, and the tribes are considered to be federal enclaves of sorts. But that's not to say that we can't accommodate people who have, you know, medical reasons to use that drug. That's just something that we're going to have to address through our HR policies. But I think that's something that can be accommodated, that a person can be employed with the Seminole Nation and use marijuana responsibly. I think that's very possible. We just have to go into the codes and make those adjustments.
Representative Coleman.
Thank you, Mr. Chair. Is compacting a strength or a weakness to tribal sovereignty?
Can be both. The issue is, as far as Class 3 gaming goes, I don't know of a way to conduct Class 3 gaming outside of the realm of the compact. But we've got a lot of work to do as far as lobbying at the state level. As I said earlier, Governor Stitt's on the attack, and he's not going to stop. So we've got to make some careful moves in terms of our leadership at the state and national level, and be as outside of the box as we can while not tripping any wires. It's a very delicate dance, but that's something that we're certainly experienced with. But Class 3 gaming is, it's the financial machine of many, many tribes, and we have to protect it. We can't jeopardize it. And I don't know of a way to do it outside of the compact environment, and all those compacts are uniform by virtue of the state code. There's also tobacco compacts, there are fuel compacts, there are interlocal agreements, which you might refer to as compacts, between the tribes and the cities and counties for even housing matters. Certainly when it comes to those types of things, we have a lot more maneuvering room than we otherwise had. But even the Native American Housing and Self-Determination Act says that we can't conduct housing business without having compacts, so to speak, with all of the local units of government, even other tribes. So there's even compacting that occurs across tribes. And I'll tell you a little story. I was the attorney for the Seminole Housing Authority as well as the Thoploco housing entity at the same time. And the Seminoles and the Thoplocos didn't even realize that they were in what HUD considered to be an overlapping service area. So we were all sharing that money. And the Seminoles said, wait a minute, you know, our overlapping area is only a matter of feet. It's that little area that we talk about in between Seminole County and the neighboring county. And so we were able to negotiate a resolution where the Seminoles were removed from that overlapping area just for housing purposes. And the Seminole HUD grants skyrocketed, and so did the grants of all of the other tribes. So that's just an example of that interlocal negotiation that can take place that can be both beneficial and risky. But it's all calculated, and we think we're the women for the job. Thank you.
The old terminology in housing was cooperation agreements many, many years ago. And at one time, the Seminole Nation and the Muskogee Creek Nation had such a cooperative agreement to build within each other's, because each one had members in each other's jurisdiction, and that agreement was in place at one time at housing. Obviously, if you go back to the treaties, there's some language there as well.
Okay, thank you. I have one more question.
Yes.
Okay, what are the tax implications of the McGirt ruling?
Well, they could be quite broad if you take the position, as we would assume you would want to take, that all of the Seminole jurisdictional area is Indian country, then there would be no state taxes due for Seminole tribal members who live and work in those areas. But here's the problem, and again, this comes back to the risk analysis. When you're talking about picking battles, it's easier to pick a battle when it comes to someone like Jinxie McGirt, who's a criminal defendant, than it is to pick a battle to say that no taxes are due. That's a hard position to take, because the Oklahoma Tax Commission brings the cavalry. They have the best lawyers that there are. And an example of that is the Osage Nation Irby versus Oklahoma Tax Commission case, which had a similar fact pattern to McGirt in terms of the position that the tribe wished to advance, but had a very different outcome. Because different lawyers, different entities, and a different overarching position, which was a tax-related position. Taking a position that no taxes are due is always an uphill battle, which isn't to say that it can't be won, but if there's another path that can be taken through a different fact pattern, through a different issue to get to the same result, like say for an example, an Indian child welfare case or another criminal case, I mean, that's something that has to be explored. Because you have to not only look at the issues, but look at the personalities and the litigators and know your enemies. And the Oklahoma Tax Commission is a venerable enemy. So it's something that's carefully considered.
I think we, as a tribal nation, must be considerate to not totally buying the line of if the reservation has never been disestablished, it has never been disestablished. Whether the Supreme Court, addressed just the Major Crimes Act or the criminal jurisdiction within their ruling in McGirt, I think some of those things can be pressed, as the attorney had said. There are specific things in property taxes that could be, a challenge at times. But I do believe, in the areas of fee lands that the tribe owns, that we could actually exercise some of those areas and charge tribal taxes if businesses were erected upon those lands. We are within the exterior boundaries of a reservation, and that needs to be not so much of a big mystery, but there are things that other tribal reservations throughout the United States do exercise. She commented on one of them earlier, and that was the medical marijuana license. And if there's a remedy to that, particular issue, because it is an issue on federal lands and or trust lands and our restricted Indian lands. So if it's something that can be resolved through our tribal code, then that's the direction that we need to go toward, because I will say, personally, we have not been allowed through HR on the government side to hire some very good candidates, and because of such issues. So if there's a way to remedy that through placing that in our code of law, then I think that's something we need to start working on immediately. But thank you for your comment. Representative Harjo?
We have a time limit, and I was just wanting to see if we could go ahead and move on to the next firm.
Any other questions? Okay, I don't see any. So, Shield Law, we appreciate your presence here before the General Counsel of the Seminole Nation. Thank you very much.
Thank you for allowing us to be here. I'm sorry I can't shake hands. I would have. Thank you.
Thank you, ma'am.
Thank y'all for coming.
Thank you.
I'm giving them time to leave the gallery. Thank you. All right, we have now, at least under new business, legal advocates for Indian country, and I believe they're going to be represented virtually today. So I believe Mr. Littleaxe, if you're present with us.
Yes, I'm here.
Okay.
Also have Charles Tripp. He's our senior partner, and Kevin Stump is an associate.
Okay, sir, go ahead and turn your camera on so that we can see you as well.
Yeah.
And I'll just give you a little bit of a breakdown how we're meeting today. The council has decided through a tribal resolution to conduct the general council meetings virtually, what we call a hybrid meeting. Some are here in person and many are with us virtually. So that's how we're conducting this meeting. So go ahead and start with your presentation and introductions, and then if there are some questions, the council, you can save those towards the end if you want.
Okay. I think we have Charles Tripp. He's our senior partner, and he's going to begin our presentation.
Can you turn them up a little bit? Yeah. Them. Yeah. Okay, sir, you can proceed.
Charles, can you hear us?
Yes, I can.
Okay, go ahead.
Mr. Tripp, if you have a camera, can you turn that on as well?
Looks like he's losing signal. I see an X on his bars. I'll begin. Legal Advocates for Indian Country is we've been in a firm since 1998. We represented several tribes across Oklahoma, Kansas. We've done some work out in Nevada with one of the tribes out there. Both Charles, Marsha Harlan, and myself are the partners in the firm. Kevin's been with us a long time. He is handling a lot of work out in western Oklahoma. My main focus is northeastern tribes, and then Charles and Marsha, they go all over. We've done Attorney General work for the Absentee Shawnee tribe. We've done some for the tribe in Kansas. I believe Kickapoo's here. and we've pretty much, dealt with all the issues, regarding the Attorney General work. I guess the main focus we want to present is that we are for Native American people. I mean, we are 100% Native American owned, operated since we started, and that's how we believe that we can provide the best services to the people. We believe we are reasonable. We work well with tribes. We work efficiently and stay out of politics. We just want to do the work that the tribe wants us to do and move forward from there. Charles?
Yes, I think that what Troy said is pretty on point. We initially started our business because to assist both tribes and to help individual tribal members. And that's what we've done now since 1998. I feel we've done an appropriate job. I think that we've worked with a number of tribes that where we've had experience in gaming, we've had experience in housing, we've had experience with taxation issues, working with health services, with a majority of the programs that tribes are going to have. And so we've been able to do that, and I feel that we've done an outstanding job, primarily because our focus is not on anything but doing what we can do that will better the lives of our tribal members of whatever tribe we're dealing with. Within all of that, we've also worked heavily in the court system, primarily tribal and state. We've done a lot of Indian child welfare stuff. So I think we have a lot of things that are that we can bring to the Seminole Nation.
Is there anyone else that's going to present for legal advocates as well? I see a Mr. Stump. Mr. Stump, are you with them as well?
Yes, sir. I'm kind of our lead associate at this point, and I cover really from north central part of the state down to the southwestern part of the state, and then out west, doing a little bit of everything. We do child support work for Comanche Nation and for the Modoc tribe, which handles several tribal court systems out in western Oklahoma. Cheyenne Arapaho, Dak and Buck, the Absentee Shawnee, Citizen Potawatomi, do a lot of those things. And then I'm also the child support attorney for Prairie Band Potawatomi up in Kansas, so I'm up there occasionally. But yeah, we do a little bit of everything. And like Troy said, we have a lot of contracts with tribes on the whole, but then we do some stuff for individual tribal members. So I occasionally will get appointed by judges to do defense work or guardian ad litem work. For the Kickapoo tribe, I've done both of those things. For the Iowa tribe, I've done both of those things. And then up at Kaw Nation, I do domestic violence work, which is custody, divorce, protective orders, things like that. So yeah, kind of a little bit of everything.
Do y'all want to take questions at this time?
Yes.
Okay, counsel, if you have any questions, if you want to direct it to the lead attorney or any specific attorney that's been speaking on behalf of this law firm, please direct it to them. If not, then gentlemen, whoever wants to answer the question can take the lead on that as well. So is there any questions by the tribal council? Representative Watkins?
I have 3 questions.
All right.
Either one of the attorneys can answer. Your thoughts on the tribe getting sports betting and esports betting at the casinos. Number 2, your thoughts on, do you see anything that the Seminole Nation can do for our tribal members on if they have good background checks, but the state marijuana card holders, it's making them unemployable on our tribal lands because of their medical issues. And number 3, are you negotiable on your hourly rate?
Well, if you don't mind, I'll kind of work that backwards. With regard to the hourly rate, we are negotiable, and part of that is when we founded our firm back in 1998, our focus was to provide good services, proper services, needed services for people and tribes based upon their fiscal and their monetary abilities to deal with certain things. And obviously, in a situation in dealing with a tribe, particularly a tribe as large as yours, there may be a number of things that need to be done and a number of hours. And obviously, the more hours that we are needed, I believe it would be appropriate to go ahead and to work within whatever you have, because that's the more hours you're needing, the more that we can take care of business, I guess, and money at that point becomes something that would be difficult for the tribe. And your money needs to be spent on tribal members, member services, things like that. So we're willing to negotiate on any of that aspect of it. With regard to the issue of e-betting, I'm going to defer that to Troy to let him pick up on that.
Well, at this point, from what I understand from the cases, is the state will have to allow it. It's like Class 3 gaming. I mean, they're going to have to allow it like they did with ball and dice before we can compact for that. There may be some. We really haven't got into that, and there may be some gray areas we can find to be able to operate. I don't think McGirt will have any. I don't think McGirt will have any aspect of it, but that doesn't mean the research won't show that it might. I believe it's a coming thing for sure. I know that East Coast Pequots was out there last October, and they were starting up their operation with one of the national fantasy sports operations, and it's really taken off up there. So it's just going to be, but you know, with the governor we have now, I don't see us really getting any good compacts or anything productive out of them yet for a couple of years.
Yes, and I also think with regard to that, you know, if that's something the tribe is interested in, certainly that's something we're going to pursue and look into every aspect and every avenue in which we can make that come about for the tribe. With that, as Troy said, I mean, the governor we have right now is someone who is not a fan or not a friend to tribes. And as an aside, which is not a direct answer to your question, but some of the things that can be done to overcome that issue, that problem, that obstacle of Kevin Spit is to start making sure that, and this is where the tribe can do things that aren't necessarily per se under the legal realm, but you know, things such as advertising, such as you know, PR. I mean, positive PR. What all is the Seminole Nation providing? Not just Seminole Nation, but all the tribes providing to this state that the state wouldn't have if it weren't for the tribes. And we need to be our own biggest supporters. We need to be our own biggest advocates. And we need to be out there and show people what all we are doing. And that if we weren't putting that in, that the state couldn't be providing all of those types of services and all of those things that their individual citizens are receiving. So I think that is one aspect of being out there. And the other is, you know, we are willing to undertake anything to go and look and see what is the best avenue, what's the best route, what's the fastest way of doing things, and what is maybe the best way of doing things to get e-sport betting, if that's something that the tribe would like to pursue. With regard to the issue of marijuana, that has been one of the biggest aspects of the problem, where you have a state that has allows for medical marijuana licenses, Under state law, of course, there are certain things you can't be high on the job. The tribe could, or the business could put certain things into place, but that cannot be held against them. The fact that they have a medical condition that requires the use of marijuana, or where the employee has a card. And so I think what has to come on there, and I think that's another thing, is depending on how does the tribe want to proceed, and we would take whichever avenue that is. But there are a number of ways, I think. Obviously, one is through negotiation. One would be through some sort of adopting and adapting some laws under the Seminole Nation that I think could be challenged. And maybe that's something we would want, is for them to be challenged, because that gets us up in front of other people to make the decisions. And with regard to McGirt, maybe this is an area where you can utilize McGirt as your stepping stone to the next area. I heard, with something like that. Because there, at this point, it's similar as before. There still are some laws on that effect about alcohol in Indian country. I mean, the thing is, we're treated, our citizens are treated as second-class citizens compared to non-Indians, and that is not the way it's supposed to be. And if we truly have a government-to-government relationship with the United States, then that's something that, one, we'd have to first attempt, I believe, to negotiate with them. But second, if they're not acting in good faith and not being the advocate they should be for the tribes themselves, then we need to force that. And, I always try to operate from a situation where I want jurisdiction to be the broadest that it can possibly be. And that's the way I like to pursue it. However, I also recognize that tribes have their own philosophy about how they want to do things and how far they want to push things. And we would certainly be willing to work within whatever the tribe would suggest on that.
To kind of jump in on the marijuana issue, this is a little adjacent to what your question was, but what I'm more familiar with is the kind of domestic and custody issues involving marijuana. And in all the state courts, it gets brought up all the time. One party accuses the other of having a marijuana card, something like that. And as the state law is now, that's something that in a custody case can't be held against you. If you're working, obviously tribal members are working off of tribal lands, and they don't have to worry about anything there. So in state courts, that's okay. In tribal courts, I've had some different experiences, and that is, I've had some tribal judges say, basically, this is federally illegal, we're going to treat it as illegal, and I won't hear anything else about it. And then I've heard some other tribal judges say, we're heading down the road towards this being federally decriminalized, so I'm going to treat it as such. And I've had tribal judges basically say, I don't want to hear about it, I don't want to know if it's happening or not, and kind of turn a blind eye to it. So I think in those situations, it's good to be familiar with the judges and the court systems that you're dealing with, and I think that can kind of help until some of these gray areas have been cleared up around marijuana.
Thank you for those in-depth answers, gentlemen. Are there any other questions? Representative Petit, you're recognized.
Yes, thank you, Chair. I noticed in your request for consideration, you did disclose a conflict of interest procedure you'd have, but I noticed in some of your areas of practice that you have several that have practice in our child support and Indian child welfare, and that's been a concern of mine, in that I would applaud you for that, in your work in that area there on that. It was previously mentioned that the negotiable rate on the hourly rate, and in review of your charges, I noticed that you are competitive also in your paralegal expense that you would have, so that would be something that we would like to consider also in the event that should your firm be chosen to represent the Seminole Nation. I do have a question about, could one of you comment on fiduciary duty? How y'all interpret that to be?
When you say, are we talking about the fiduciary duty of our law firm to the tribe?
Yes.
Yes. One of the reasons we put out, and again, we'll talk about the issues of things such as confidentiality and things along those lines. You know, there is a situation where some firms, and I'm not saying we haven't had that situation, where you represent one entity and you also represent an entity elsewhere. The first thing that has to happen if there's anything in conflict is for us to notify you, make sure you're made aware of that, and that we owe a fiduciary duty to our tribe, which would require the tribes who work for us, which would require us to say to at least one of the tribes, and I can tell you right now, if we were representing the Seminole Nation, it would not be to them, because as Attorney General, that is about that's probably the highest level of fiduciary duty required. We would notify the other tribe that we can no longer work with them, that we would no longer be able to provide whatever services that potentially could be in conflict with the Seminole Nation. With regard to the Seminole Nation, as large as it is, as many departments as it has, as much work as it is doing, and as many things as it's involved in, we also have recognized that that's a possibility that this could arise. And if it does, we're prepared to make sure to let the other tribe or tribal department or whatever it is know that we can no longer provide services for them because we owe this duty to the Seminole Nation.
That suffice for you, Representative Petit?
Yes, thank you for your comments.
Any other questions from the General Counsel? Representative Coleman, you're recognized.
Thank you, Mr. Chair. Gentlemen, is compacting a strength or weakness to tribal sovereignty?
Well, I mean, I believe that compacting, it's a little of both, because in terms of compacting, it should be a situation, and I know we're talking about compacting as a state government, but if you think about compacting in this term of contracting, we do that all the time. We contract with businesses to bring on, I'm making something up now, but let's say we were going to do solar power. And we have a business that wants to do business with the tribe. You're going to contract with them. There are some things they're going to want. There's some things that we definitely have to have. And so you give and take within that. Do I think it's a weakness? You know, truthfully, if my belief is, as a tribe, for the most part, particularly dealing with the state, compacting wouldn't be an issue if both sides come to the table with the same idea that we should be trying to work together. The state of Oklahoma does not do that at the present. So at this point, compacting is a weakness to the tribe because it is they're stepping on our jurisdiction. And I'm not saying we should step on their jurisdiction. What we should recognize is that this area that we are both living in, these communities are people that we owe services to, we owe a debt to because of all they've went through, and let's work and get something that's the best for them completely, and put aside some of the things that, the easiest one is the issue of taxation, I think, particularly if you do push the McGirt decision. If you push McGirt, you know, obviously the outcome is that Seminole Nation members who work on Seminole Nation land shouldn't be taxed, have income tax. You know, regardless of now whether it's fee land or it's trust land or whatever. You know, state of Oklahoma, yes, is going to fight that. But the truth of the matter is, we provide services for those members, for those people as well. And so we need to be able to gain something from that. And again, I think that compacting is going to be an issue where if they're willing to sit down and compact and we can get what we need out of it, And that's what we have to figure out as a tribe. We have to figure out what is it we won't settle for anything less on, what is it that we can negotiate on, and what is it we're not going to give up, at all. Or what is it that we're going to throw out there just as a tool for negotiation that we really don't care about. And as long as we can do those things, great. And if we can work together, great. But if we can't work together, then yeah, unfortunately, it comes down to litigation and going to court and asserting certain things. And McGirt has given the tribes this, I'll call it stepping stone. I'll just be real honest with you. I got invited, it was in the 1990s, to speak at Sovereignty Symposium. And one of the things I told them then is that the tribes had their reservations were still intact, and that the state of Oklahoma was the enemy. I didn't mean it quite like that, but they are always against the tribe and the tribe's use of trying to assert their jurisdiction. And as you can probably guess, I didn't get invited back to Sovereignty Symposium to speak after that. So, but that is my belief. I mean, who's going to advocate for us? We can't expect the state to do it. We really can't even sometimes expect the feds to do it. We have to do it ourselves. And a lot of that's going to come, I think, in preparing our codes, in preparing our policies and procedures, in preparing things and looking forward to the things that are coming down the line. I mean, we wouldn't have had this discussion about marijuana, even medical marijuana, 10 years ago, 12 years ago. But we need to also be looking at what are the things coming down the line that we could pick up on and maybe be on the forefront of and get ahead of the state or the feds or other tribes for that matter.
Thank you. My next question was going to be, what are the tax implications of the McGirt ruling? And I think you've answered part of that. And or if you would like to add more to it, you're more than welcome to. Thank you very much, y'all.
All right, thank you. The only thing I'm going to say is the tax implications. Obviously, we got issues that would be looked at in terms of property taxes. You've got issues with regard to income taxes. Truthfully, one of the areas of looking at is, if we're a reservation and we've been a reservation, I mean, you can't say, okay, we just became one because of the McGirt decision. That's not what it says. It says we have always been a reservation. So, I mean, even back taxes and things are things that are there. What the back taxes, I think, are beneficial for, though, is not to go and try to collect them back, but they are a good tool for negotiating the future. And that's where, the business taxes, I think anything that you can think of that relate to taxes that are within the jurisdictional boundaries of the Seminole Nation have now come into play as possible issues to either negotiate on and or litigate over.
Thank you very much.
Any other questions from the General Counsel?
Chair.
I see Representative Narkamy. I see your hand there. You're recognized at this time.
Thank you. First of all, let me thank you gentlemen for coming here today and for submitting your proposal. My question is pretty basic. I reviewed your proposal, and I just would like to ask if any of the lawyers are currently members of the Seminole Nation Bar Association.
Yes, we are. I know that Kevin and I are. In fact, I am at present the president of the Seminole Nation Bar Association.
Okay. Thank you much.
Thank you.
Okay, if there's no other questions, and I don't see any hands raised virtually or anyone here in the gallery. So gentlemen, we appreciate legal advocates for Indian country being in the presence of the General Counsel of the Seminole Nation, and for your in-depth answers as well to the questions that were asked. We appreciate you being here today.
Thank you very much, and we appreciate the opportunity to discuss this with all of you. Thank you very much.
Thank you very much.
All right,
Thank you very much.
Okay, they are offline now, according to what I can see. At least their camera's not on. I'm looking for VCR, interim director. Yeah, they're not watching it back there, so they don't know that the interview is ending. We have one more request for proposal from Duvall and Associates. And they're here in person. General Counsel, before us we have Duvall and Associates. Ladies and gentlemen from the firm, if you'll stand, if some of you who are going to speak, go ahead and stand in front of the table. There is a cordless mic there for you to be able to pick up. There you, Valerie has it. And you're welcome to stand on this side of the table and face the council that's present. And the camera will also pick you up for the council representatives that are with us virtually. And I think this firm already knows that we voted as a nation in a tribal resolution to have hybrid meetings at this time. So even though you see a limited amount of council representatives present here before you, we have a total of about 26 council representatives either present or virtually with us today. So there's a lot more council representatives listening to your presentation this morning than the ones that sat before you today. So at this time, we'll turn it over to Duvall and Associates and for a presentation. You can do introductions or whatever that is as you desire.
Thank you, Chairman. Is it all right if we take our masks off while we speak? Is that all right with everyone?
No, you keep them on.
Keep them on?
You keep them
Okay.
on. That's fine.
So
it's a very different times right now with the different variants.
I just want to be sure that we can speak clearly and everyone can understand, but that's okay. I'll try to speak
Just
more
put the
loudly.
mic up to your mouth. That'll
Okay.
help. There you go.
Can everyone hear? Oh, that is better. Thank you. Thank you. My name is Valerie Duvall, and most of you probably know me. Our firm, we have served as interim AG since last September, and we have really appreciated the opportunity to work for Seminole Nation in that capacity, and we appreciate the trust and confidence that you put in us when you voted for us to act for you during your transition period. I will tell you a little bit about myself, and then I will do I guess a brief introduction. My name is Valerie. I have been in practice about 25 years. I've been in practice in Oklahoma about 20 years. My background before I went to law school was in finance. I have a master's degree in finance. I was a banker before I went to law school. I went to law school as an older person. I am an older person. After I completed law school. I got an extra degree. It's called an LLM in taxation. So I have a background in financing and taxation. And that has kind of shaped my career. So I'll go into a little bit of my experience later, but I just wanted to give our initial presentation. You probably know, and it's probably been in the news a lot, as of Friday, the 21st of January, when the U.S. Supreme Court decided not to rehear any of the state's arguments on McGirt, in our opinion, we entered one of the most dynamic periods and opportunities for tribal growth that we've experienced in our lifetime. And it's exciting, and we are excited to be at the forefront of that and assist Seminole Nation if that would be the General Counsel's choice. You know, because of what's gone on in the political environment with the U.S. Supreme Court's decision, we have the opportunity to expand both our criminal and our civil jurisdiction, we believe, and exercise more governmental authority over our lands. So, in addition to those things, we understand that as a general counsel, you have a fiscal stewardship and responsibility to your people, and we understand that you're very sensitive to legal fees and what would be charged for things, and we want you to know that even though there are several of us, we are not the law firm that is going to charge you for 5 people being in a meeting or reviewing and writing a report for things you didn't want us to do. We understand your responsibility, and we understand our responsibility. In this regard, in addition to what we've offered in our request for proposal, we're going to offer, because serving as interim AG, we've become aware that there may be some of your codes of laws, your ordinances, that maybe have not been updated at the level that you would like them to be updated. I could go into some specifics, but you know, when you pass ordinances, they affect other ordinances. And so, as over the last few months, we've seen that the ordinances, your codes of laws, need to be updated, and we would like to take on that project for you at a discounted attorney hourly rate of $150 an hour. So that's a substantial discount from what we had in our proposal. In that regard, we would work with the General Counsel Secretary. Under your codes of laws, the Attorney General's office is tasked with getting the ordinances updated, but we would work with General Counsel Secretary and the General Counsel representatives and obviously the executive office to get that project done. And so we would pledge to do that project for you and make it a priority, because when we don't have access to current laws, we're all at a disadvantage. So we would make that a priority. And we can talk more about that in a minute. I want to talk about our team. And so we have a team approach to the Attorney General. Several of us are here, but because of COVID, we didn't bring the whole team. We think as a team, we can provide a full service approach to legal services for the nation, especially during this really dynamic period of growth because of where we are. We have the diversity and a breadth of legal practice areas, and the other team members will talk in a minute. Because of our areas of law and our age and our years of experience, we think we can provide the best service to the nation. We've worked for the Seminole Nation for almost 2 decades now. Some of us, me and Jean, have worked together for almost 2 decades, and some of the younger ones, Garrett and Tori and Tim, have clerked for us, for me and Jean, when they were in law school. And anyway, we have worked together for a long time. We are like a family in many ways. I want to read this one line I wrote. We have the ability to respectfully disagree with each other, discuss different ideas, and reach the optimal outcome by working together to solve problems. So some of you know our background, and I just wanted to clear the air on that. As for me, my area of expertise is tax, economic development, and finance. I explained a little bit about my background, but if we are elected and as General Counsel directs, it would be my personal goal to assist Seminole Nation in asserting its sovereign rights to greatly increase revenue generation. I believe revenue generation can occur in the areas of sales tax, property tax, severance tax, and income tax regulation. And let me go on to add that the ability to regulate, enforce, and provide tax exemptions expands with the civil jurisdiction of the Seminole Nation under the McGirt ruling. I believe these areas will provide greater revenue generation for the nation to better facilitate economic growth and opportunities, economic opportunities for all of the tribal membership. We were asked in the RFP to discuss our expertise in Indian gaming. I believe, or we believe, there are 4 major components to effective legal representation in Indian gaming. And those are regulatory, enterprise management, finance, and tax. And we believe our team is best suited to assist Seminole Nation in each of these areas. And so we've got limited time. I'm going to let the rest of the team here introduce themselves, and I'll start with Tim Brown.
My name is Tim Brown. I have been working for the nation since before I graduated from law school. I started working with the former Attorney General, Jenna McBee, who trained many of us in our practice in Indian law and also in the way that we manage our work and our dealings with our tribal clients. I've been the BCR's primary legal counsel for over 16 years. I've also been the nation's lead prosecuting attorney for a little over 2 years now. And I feel like I had to volunteer to partner with Valerie Duvall because she has the experience and the expertise in the areas of taxation because that's what the nation needs. The nation, at this point in the McGirt era, we need more revenue. And I think that's the area that we're going to lead. I've also worked for many of the other tribes. I've worked for the Choctaws. I've worked for the Cherokees as their counsel attorney. And I know they don't want to go that route. And the reason they don't is because they have revenue through gaming. They have extensive revenue through gaming in their businesses. They have no interest. I have brought up sales tax to them over and over again. None of them have any interest in leading this fight against the state. We have sales tax revenues that the state has been collecting from our tribal members for many, many years. And we have an existing sales tax code that needs to be enforced, and we need to start collecting that. And I believe Valerie Duvall can help us do that. So I think that's the reason that I have partnered with Valerie, and I'm here today to help try to support the Seminole Nation in this fight.
My name is Gene Burtman, and I, too, have represented the Seminole Nation in the past in various capacities through assistance with Jennifer McBee as Attorney General, with the gaming enterprise, all the different entities. I've had a lot of familiarity with the nation. I've always been brought on in a litigation capacity. Generally, my practice is focused on litigation in state and federal court and appellate courts. I'm licensed in each of the federal courts here in Oklahoma, including the Eastern District, which is what this nation's covered. I'm licensed in the 10th Circuit. I'm licensed in the U.S. Supreme Court, licensed in the Court of Federal Claims and the D.C. Circuit Court in Washington, D.C. So if there is a matter that needs to be tried or needs to be handled by the nation, because that's what the federal government or the state of Oklahoma pushes this tribe to, we have the team approach allows us to be able to help handle that and bring those claims to the forefront, protect this nation's sovereignty. And so that's what I've done in the past, and that's why I'm part of this team, and I think that's what we can do in the future. Thank you.
Okay, hi, my name is Victoria Holland. and I'm a member of the United Kituwa Band of Cherokee Indians in Oklahoma, or the UKB. And I've been working with the Duvall team for over a decade because I started working for them when I worked for the UKB. And while I was working for the UKB, I learned the daily struggle that tribes face in exercising their sovereignty and how important it is to have good legal representation. I decided I wanted to go to law school, and the attorneys you see before you really encouraged me and helped me make that decision. So now I am able to help my tribe and others. Aside from my kids, Indian law is like my favorite topic. I talk about it all the time. I work for a lot of different tribes in various capacities, and Val gives me all kinds of to-do lists, so whatever she tells me to do, I'm on it. I'm a prosecutor for a couple of different tribes where I do criminal work, Indian child welfare work, juvenile work, and civil infractions. And I am a prosecutor with Tim here for the Seminole Nation. I work on gaming matters. I've drafted ticks and SICs, and I work on licensing issues and employment issues and contracting issues and compacting. You know, given the current state of affairs, I don't know if we want to talk about that because that's a whole other discussion. But I really love doing all of that stuff. My favorite thing to do is economic development for tribes. And that's because tribes have this goal of providing quality services for their tribal members. And one of the ways that they do that is through economic development. I love seeing that come to fruition and seeing tribes be very successful in doing that. I will exercise sovereignty to the extent that a court tells me that I can't. And we would love to be part of the Seminole Nation and represent them as the Attorney General.
My name is Garrett Eller. I have been working with Valerie Duvall for just under a decade, and her entire time working for Seminole in various capacities led me to also working with Seminole Nation for that length of time. I've had a more active role with Seminole in the past 4 years. I have been the primary go-to attorney in our office for the Seminole Nation Gaming Enterprise. My expertise is in tax, Indian child welfare, legislation, and just various other areas. Primarily, I focus on the tax aspect. I built a great relationship with the IRS and create a very important connection with all of our issues with filings and resolving any issues that we have with our gaming enterprise and with the IRS. I've enjoyed every minute of working with the Seminole Nation, and I look forward to utilizing my expertise or my areas of practice in legislation, tax, and improving the Seminole Nation. I work with multiple tribes across the state. I've got various contracts in my private capacity and along with Valerie, and I want to bring all of that experience here and work closely with you all. I look forward to it.
Okay, we'll open up the floor now for questions from the General Counsel. And gentlemen, the two gentlemen in front of me, if you could just kind of separate a little bit so I can see the floor, I'd appreciate it. Thank you. Okay, and I'm looking virtually. Are there any questions at this time? Representative Watkins, I see your hand. You're recognized at this time.
Chair, I've got several questions for the attorneys. One is going to be directed to Ms. Duvall. As a AG for SNGE, do you see a conflict of interest?
We do not see a conflict of interest in representing the different agencies of the Seminole Nation. In fact, your code of law says the Attorney General should represent the different agencies of the nation unless the agencies are given the authority to hire legal counsel on their own, and that would be this body that would give them that in their codes of laws. We do not see a conflict in representing multiple bodies of the Seminole Nation as Attorney General.
Okay, and also, I guess, Mr. Brown, you're the prosecutor for the nation, so you don't see a conflict of interest working with the Duvall firm?
I don't see there being any conflict as, you know, essentially you've got multiple, it's like multiple fingers on the same hand. These are all going to be working together. As a prosecutor specifically, prosecutor's easy. Unless you're a defendant, I'm not going to have a conflict. The VCR is the one that would be more questionable, but I've been serving as the VCR attorney. I served as VCR attorney whenever previously under Jenna McBee, in addition to also serving as an assistant attorney general at that time. The VCR is never going to be in conflict with the attorney general. The VCR regulates other agencies within the nation, so that is one of the things that I, as the VCR attorney, have to be aware of. That we've been in that situation before, and I feel like I have the independence to handle that in an appropriate manner. And so I think that's, like I said before, I mean, we've had a situation before, and it's been 15 years ago. I think Willis may have been around whenever we were having to collect the gaming fees from SEG, or back in that day, I think it was SINDOC. It was not something that Attorney General at that time, Jenna McBee, actually, she understood this is the way we handle this. And so I think that's something that we continue to do.
Yeah, okay. Then the two main questions for your firm, your thoughts on the tribe getting sports betting and esports betting at the casinos. And the number two question, your thoughts. Do you see anything that the Seminole Nation can do so that the tribal members who have good background check, but the state marijuana card holder, it's making them unemployable on our tribal lands because of the medical issue?
Okay, I'll take the marijuana question first. So, first of all, you guys make your laws, right? We advise you what the law is, and then you guys make that determination. So, right now, the marijuana is still a federally it is still illegal. But in 2012, I think it was, they came out with the Cole Memoranda, which basically said that, listen, states, as long as you're following these guidelines, we won't prosecute, we'll turn a blind eye to it. So when the state of Oklahoma allowed for medical marijuana, they opened the door. So tribes now have the authority in Oklahoma where they could make marijuana use recreational if they so desired. The problem is whenever you have federal grant funding, you agree to abide by all federal laws, and federally, marijuana is still illegal. Now, as far as individuals and their eligibility for hire, that's a decision that this body can make because you guys are the legislative body. So I would, no offense, but defer it back to you because that's something that you guys need to decide as a nation. And for sports betting, I am all for economic development. So if the tribe wants to engage in sports betting, then I think we should explore those options. The problem is, as you've seen with the compact negotiations, Governor Stitt offered things that were not approved in the model tribal gaming gaming compact. So the issues become, what has the state of Oklahoma's legislature approved Governor Stitt to offer? Now, we did have some amendments that happened, so we don't have to negotiate a whole new compact. If we did decide to do sports betting, we would just need the state of Oklahoma to allow for sports betting, and then that could be as easy as attaching an addendum to the current compact.
And if you remember, the most recent addendum we had was for ball and dice. And so there is precedent for adding addendums to the gaming compact, probably more likely under a more friendly governor, but there is that possibility for us to do that.
Thank y'all so much.
I want a little more clarity on the marijuana question or medical cannabis, because obviously you had stated that if we would place that in our law as far as employees, that it possible, excuse me, the possibility of it being allowed as far as hiring within our tribal lands, those particular candidates that have a state license for medical cannabis. How would that, passing such laws of that nature, align with the federal requirements on trust or restricted lands? I mean, would there still be a situation with the federal government
Again, it's still illegal federally, so your biggest issue will come down to your federal grant funding. So in a lot of your federal grant funding, you agree to abide by all federal laws.
Sure.
So that's really where the hangup is. I think that there are options that you have. Sometimes there's beauty in ambiguity. So if you require random drug testing, maybe you just don't test for marijuana. You know, you have different options without flat out saying, like, we agree to allow for marijuana use. You have options, but just note that as the legislative body, you guys have that authority to make those determinations.
Well, there's no doubt that the General Counsel of the Seminole Nation has that authority, but will it come back to have an emphasis on from the federal government? Now, we know that there are other tribes that have incorporated that within their tribal laws, because we really need to know the whole scope of it. Obviously, Ms. Duvall is the interim attorney for the Seminole Nation at this time. So I know a lot of our members have asked us to look into it, to proceed with the possibility, because I will attest that there was many good candidates that we weren't, because of the existing laws that we have and policies within HR that would not allow us to actually hire those folks once that we discovered that they had, you know, a medical cannabis card issued by the state to come work on federal trust lands, which is, I think a lot of people, even within government, doesn't realize that trust lands are held in trust on behalf of that nation by the United States. Restricted lands are a little bit different. But I guess we can approach that, you know, if indeed the firm is...
Well, and I would just like to add that I can't give you a good answer because it kind of varies from the district courts on what they will actually prosecute. I've actually seen in the Western District of Oklahoma, they will prosecute non-Indians who have marijuana on Indian country, but the Eastern District, to my knowledge, has not been prosecuting any marijuana cases. So it varies from the different federal courts on what they're actually prosecuting because, again, we don't have a good law that says that it's still, or that it's not illegal. We just have that Cole memoranda which states that the DOJ won't prosecute as long as you're doing this, this, and this. So I would love to give you a good, solid answer on that, but I don't want to tell you wrong.
Correct. I appreciate your comment. Any other questions from the council?
Thank you, Ms. Duvall.
Representative Coleman, you're recognized at this time. Did someone speak from virtually? Did I hear a voice? Okay,
Yes.
we'll recognize you after
Before
Representative Coleman. We'll recognize you after Representative Coleman. Thank you.
My question is to anyone who wishes to answer this. Is compacting a strength or a weakness to tribal sovereignty?
I believe we all have an answer on this, and briefly might share, I think for my purposes, for tax and economic development, it is a necessary evil. It is the easiest way to to do business with the state government right now. I recognize that we have treaties and we have treaty rights. And maybe treaties are a way to, I guess, assert those rights. But if I were speaking just for tax, I would say that compacting is a necessary evil.
And I would also emphasize the aspect of describing it as a necessary evil from the standpoint of the limitations that the federal government has put on our tribal sovereignty. I think that it's the most efficient way to get from point A to point B. I think, you know, specifically on the hunting and fishing rights, I think that's real popular right now. It's one thing to say we all have the right, or tribal members have the right to hunt and fish within their reservation lands. But at the same time, exercising those rights can turn into an individual liability, where an individual is maybe prosecutor, or an individual tribal member may have to deal with the ramifications of what the state decides to do, whereas compacting essentially protects those tribal members by, you know, trying to compromise. And so, unfortunately, like Val and I both have described it as a necessary evil, it's one of those things that it's just it's the most efficient way to get to where we want to be, which is to be able to exercise our rights. So.
I have a whole lot I could say on compacting, but I think Gene said it best earlier, and so I'm just going to defer to him.
Compacting is the scheme the federal government has put us in at this point. So it is what they have determined we have to do to get along with the state. But it's your choice whether you compact. Now, it comes with risks, as with anything else. If you choose not to compact and assert your rights, then we generally wind up in federal court or arguing with a judge about that. If we deal with the compacting issue and go into it, then we're again negotiating. But at some level, compacting is what they used because that's what European history taught them to do, right? When the governments in Europe got into a fight and they wanted to stop, they went to treaties. The federal government here calls it a compact. Unfortunately, the federal government stacks some of that case against the tribe by giving more of the power to the state as opposed to the tribe. So it's just, in my opinion, it is how far you want to go. If you want to assert your rights, we're here to assert your rights. That's our job. If you want to work with the state to see if you can come out with a good result for the nation, exercising your fiduciary responsibility, then that's what we're here to do. We have experience in both. We've experienced fighting compacts, we've experienced negotiating compacts, and that's what our role is to help you get the best result and give you advice as to what the consequences or risks are with all of that. But that's your choice on compacting. That's not ours. So that's all. And we're here to help you with every direction you would want to go.
Thank you. Ms. Duvall, what is the tax implications of McGirt-Wheeler?
How much time do you have?
I've done several presentations on this topic this year. That's why Tori's kind of making fun of me. I believe that regardless of what the state of Oklahoma says about McGirt only relating to criminal jurisdiction, that can't be correct. We use the same statute for criminal jurisdiction that defines all of the civil jurisdiction within most of Indian country, not just in this state. And if that's the definition we're using, then that applies to tax also. I think in the areas of sales tax, that is where we have our greatest opportunity for revenue generation. And I'll go back to compacting for just a split second, because when you collect sales tax from anyone doing business with that establishment. And it might be tribal people, it might be non-tribal people, but there has to be a fair splitting of the tax between all of the sovereigns, and that includes the tribal sovereigns. And here, even today, we have not shared in sales tax, and so I believe that's very frustrating. As far as severance tax, oil and gas, I defer to Tim on that. He probably has stuff to say about sales tax too. As far as income tax goes, there's some legal tests about who can assess an income tax. The tribe has the right to assess an income tax, but why would, other than, that would be a decision for the general counsel to make. But, the law is pretty clear that if you live on tribal land and you work here, that you shouldn't be paying state income tax. Federal is a whole different story. I mean, there's so many ways that you have to slice and dice tax, okay? Tobacco tax, same thing. I just went and negotiated with the governor's legal team on tobacco tax. What they offered up was most of the other tribes are within a tobacco compact still until 2024, and that has gone to the tribe or the nation shares in 50% of the tobacco tax. The state gets the other half. They propose to leave us in that, situation until 2024, and then going forward, this governor wanted 75% of the tax, with the tribal one getting 25%, which is disrespectful, and no tribes that are out of compact have agreed to that yet. So I am old enough that I remember the 2004 gaming compacts, the 2014 tobacco compacts. and anything in between. And now we're coming to a time of negotiating compacts again. We all know what happened with the gaming compacts, and we could talk about that for 10 hours if I gave one of them the microphone. That's what would happen. But I think that there is a way that we can assert our sovereign rights, not just Seminole Nation, every nation, especially with regard to those types of taxes I've talked about, because under, it's called the Montana test or the Montana case, if you decide to do business with Seminole Nation or it's land-based, it's, if you are an enrolled member, there are ways you consent to taxation of a nation or state. And when you enter those kinds of business transactions, where you live and who you're a member of, you consent to tax at some level. And I'm not saying we should tax anyone more. I'm saying there should be a fair share of the current tax. Did that answer your question without me? Okay.
I have a question on the living within Indian country and then working within Indian country on income tax. You kind of mentioned that in that dialogue there. We always have known that on restricted and trust lands, and if you work on trust or restricted lands, you don't pay Oklahoma sales tax. Now, you can correct me if I'm wrong in what I heard, but within the definition of Indian country, which is, of course, within the exterior boundaries of a reservation, so it doesn't necessarily have to be lands owned by the tribe, but just within the exterior boundaries of that reservation. If you live there and work within that reservation, that income tax for the state could possibly, or in your opinion, could possibly not be applied to those Indian people.
We would argue that you should be exempt, and I can tell Tori is busting at the seams. So Tori, do you want to add one thing?
I ask these questions for clarification, Council, because these are often things that's not expounded on, maybe just mentioned in a sentence.
So the general rule is that the state lacks jurisdiction on Indians in Indian country. And as Val previously stated, we use that criminal definition of Indian country, which is 18 U.S.C. 1151. And 18 U.S.C. 1151 says that Indian country is reservations, dependent Indian communities, and then allotments / trust lands, or kind of both. So anyway, within that, prior to McGirt, we treated the state of Oklahoma like it was a checkerboard, okay? So you have some parcels that are trust or restricted fee, and those were Indian country under 18 U.S.C. 1151A and or C. Then, when we had the McGirt decision and its related decisions come back, it redrew the reservation boundary. So now, everything within that checkerboard is Indian country because it's a reservation under A. Within that reservation, you still have fee lands, trust lands, land in all sorts of tidal ways. So within that reservation, if you have trust lands or restricted fee lands, that's Indian country in and of itself. So you can think of it as double Indian country, if you will. So if the whole reservation is Indian country, then theoretically, the state lacks jurisdiction to impose any civil regulatory mandates on Indians in Indian country, which would include income tax.
Thank you. Representative Harjo, I see your hand there. You're recognized at this time.
I just wanted to know.
Representative Harjo, you're cutting out.
Can you hear me?
We can now. Thank you.
I was just checking to see where we are on the time limit for this presentation.
Can you repeat that question again? We can't hear you very well.
The time limit? How are we on the time limit?
The time limit for the interview.
Okay, you're ready to move on. Okay. If you're talking about a standard time limit of 15 minutes, we have allotted time for the interviews a little over that because this is not a standard presentation like a director anyone else that comes up before this council.
I just feel like we've given this portion of the presentation a little bit longer than the previous two. So I just wanted to make sure that we're being fair with the time limit.
Okay, thank you, Representative Harjo. If there's no other questions, then we can move on from here. Okay, there's no other questions that I can see from the General Counsel. So thank you, Duvall and Associates, for being before the General Counsel of the Seminole Nation this morning. Thank you. I'm waiting for them to exit the gallery, and they're just about out of the gallery. Okay, we've heard from 3 firms that had sent an RFP within the designated time period, and we heard from all 3 this morning. So what is the desire of the council to do at this time on as far as the Attorney General is concerned? What's the desire of the council? We're open up.
Here.
Is that Representative Fulbright?
Yes, it is.
Representative Fulbright, you're recognized.
Our band had talked about the law firms, excuse me, and I'd like to make a motion to for Valerie Rose Duvall to be our Attorney General. And that's for second.
Second.
And there was a motion from Representative Fulbright to select Duvall and Associates, and the second came from, was that Representative Dethridge? Okay, we're in discussion at this time. There's a motion and a second, and we have the hand of Representative Narkemy. You're recognized at this time. Representative Narkemy, you're recognized at this time. Representative Narkemy, can you hear the chair?
Oh, I was just going, I was going to recommend that we mull our thoughts over and pick this back up at the end of this session.
There's a motion and a second on the floor at this time. If those who made the motion want to bring it back at the end of the session, there's no motion one way as far as tabling is concerned till the end of the session. So if there's not, there is a motion on the floor and a second. Any discussion? Representative Fulbright?
Yeah, I know we've taken these, because it's on the agenda, that we've taken these to our bands and we've all made our decisions at that time. They all had their resumes and we've all went through them. So I feel like at this time we should be ready to go ahead and vote on them. And as far as Valerie goes, I mean, she is, what she said in her presentation as far as updating our code of laws at a reduced price, I mean, that alone to me, that is the utmost importance that we need right now. I mean, there's many others, of course, but that particular item, I feel like, I mean, we're just kind of scrambling right now on different, when we pass laws, you know, like you said, it coincides with another code and stuff. So that particular item, I feel like, you know, he didn't say that until today. That made me decide even more for their law firm. But like I said, we've taken it to our bands.
Any other questions? Any other comments? I'm giving the virtual council representatives time because of the technology. We have Representative Petit, you're recognized.
Yes, Chair. In this situation here, will there be other resolutions present or recommendations presented for the additional firms that presented their RFPs today? Or will we just, because I understand there's 17 of us are new to this. How will this take place? Will we vote on each one individually? Or?
Well, normally what happens is sometimes there's a rating of the general counsel, which firms to consider, as Mr. Narcomelli kind of alluded to maybe bring it back at the end after everybody's kind of had a little more time to think about it, because the presentations just ended just only a few moments ago. When there's a motion and a second on the floor, and that motion was to approve Duvall and Associates as our Attorney General, then that's the motion that we'll be voting on at this time. If that was not to get the vote, then obviously someone could make a call for one of the other firms.
Okay.
But whatever the council votes on any given motion, the majority stands to whatever that vote would be.
Chair, I call for questions since there's already a motion and a second.
Secretary, call the roll, please. This is for Duvall and Associates to be the Attorney General of the Seminole Nation. Secretary?
Leetta Sampson,
Yes.
Anthony Conley,
Yes.
John Archemy,
Yes.
Rena Tiger,
Yes.
Anastasia Pittman, Anastasia Pittman,
Yes.
Terry Edwards,
Yes.
Terry Edwards,
Yes.
okay. Nancy Fixico, I'm sorry, I couldn't hear you, Nancy.
Yes.
Ida Gonzalez, Ida Gonzalez, Tamara Downey. No. Can you repeat that?
She said no.
Okay. Leon Petit,
No.
Joseph Billy,
Yes.
Delois Harjo, Delois Harjo, Karen Fulbright,
Yes.
Ann Borba,
Yes.
Stephanie Lambert,
Yes.
Dina Yesla,
Yes.
Lottie Cootie, Lottie Cootie,
She said no.
okay. Andrea Scraper,
No.
Ella Coleman,
Yes.
Shirley Watkins,
Yes.
Natalie Harjo,
No.
Tiffany Thomas,
No.
Catherine McCoy,
No.
Charlie Hill,
No.
Tiffany Cully,
Yes.
Danita Harjo,
Yes.
Willis Dethridge,
Yes.
Desiree Emerton, Desiree Emerton. Okay, I have a count of 17 yes, 8 no, 0 abstentions.
With a count of 17 yes, 8 no, 0 abstentions, a motion to affirm Duvall and Associates as the Attorney General of the Seminole Nation are declared to have passed. Okay. It is, we're going to go back to the original order of the agenda. We could take a lunch break right now. There are some council representatives that inform me that there are some things that they are probably going to bring up from Tribal Resolution 2022-04 to 2022-10 to possibly be placed on another meeting for more information on those particular resolutions. If that does materialize, if the council decides that that's what they're going to do, we could push on through and complete the council meeting probably within the next 30 minutes. But if it doesn't happen, then we'll go through all of those. What is the council? We're going back to the original order at this time, and it is the 12 o'clock hour, so if you want to take a lunch, we can. If not, we'll continue. I don't hear anyone wanting to take a lunch break, so we'll continue. We're back to the reading of minutes of the last meetings. Representative Petit.
Chair, since we've already gone out of order and we've had the election of the new Attorney General, could we go ahead and go to this verbal resolution now and get this in place and have it signed a number?
Well, when they make a motion, that is in the form of a verbal resolution. So it'll be documented as a verbal resolution from Representative Fulbright.
Okay.
Yes.
Thank
you. I make a motion to waive the reading of the last meeting's minutes and ask for a second.
What was that motion, sir?
There's a motion to waive the reading of the last meeting's minutes, which is two of them, September 30th, 2021, October 21st, 2021.
I would
Second.
I would share.
Okay, we have a second, and I heard somebody from virtual, but I see Representative Deathridge.
Yes, sir. In that motion, does that motion also include to just receive the minutes as accepted? I mean, as presented to us?
Representative Lambert, clarification on the motion. Is that to accept waive the reading of the minutes, or to accept them as they were
Chair,
printed?
that was Representative. Yeah, that was me. And yes, that will include the acceptance as well.
Oh, okay.
Thank you for
okay,
that
Representative
clarification,
Harjo.
Representative
That was Representative Harjo that made the original motion? Okay, thank you for that clarification, Representative Harjo. Okay, this is to accept the minutes as written, but to waive the reading of them. Secretary, call the roll.
Leetta Sampson.
Yes.
Anthony Conley.
Yes.
John Markamy.
Yes.
Rena Tiger.
Yes.
Anastasia Pittman.
Yes.
Terry Edwards.
Yes.
Nancy Fixico. Ida Gonzalez. Tamara Downey.
Yes.
Leon Petit.
Yes.
Joseph Billy.
Yes.
Delois Harjo. Delois Harjo. Karen Fulbright.
Yes.
Ann Borba.
Yes.
Stephanie Lambert.
Yes.
Sina Yesla.
Yes.
Lottie Cootie.
Yes.
Andrea Scraper.
Excuse me. Yes.
Ella Coleman.
Yes.
Shirley Watkins.
Yes.
Natalie Harjo.
Yes.
Tiffany Thomas.
Yes.
Catherine McCoy.
Abstain. Abstain.
Lois Harjo.
Charlie Hill.
Abstain.
Abstain.
Tiffany Cully.
Yes.
Danita Harjo.
Yes.
Willis Dethridge.
Yes.
Desiree Emerton. I have a count of 23 yes, 2 abstentions.
Okay, with a count of 23 yes, 2 abstentions, and we declare that the reading of the minutes is approved as written. Okay, unfinished business. And before we get into unfinished business, we do have Duvall and Associates here, and I just want to affirm to them that they have been selected as the Attorney General of the Seminole Nation of Oklahoma. And I know they probably want to comment at this time, but we'll leave those comments to the end of the meeting. And we're into unfinished businesses at this time. So we have TO 2021-08, sponsored by Willis Dethridge. It comes off the table because it was tabled until the next meeting, and we're at that next meeting. Representative Dethridge, what do you want to do with this particular ordinance?
Did you, excuse me, sir, did I understand that this motion is off the table? I mean, this resolution is off the table at this particular
There was a
time?
clarification in the area of the order of the meetings, and when there's a motion to table and it has a second, the clarification in the rules of order is this, that the meeting that it comes up at, it comes off the table at that point. So yes, we're off the table with this.
And I make a motion that I want to withdraw PR 2021-08.
Okay, the sponsor of that billing, that ordinance amendment wants to withdraw it at this time. There's no need to address
Let me
it.
expound on that just a little bit. I have visited with SNGE, and they are in the process of redoing Title 8 at this particular time, and sometime in the near future, they're going to ask somebody, myself or some other council representative, to sponsor that particular legislation, and so that's the reason I'm withdrawing. So.
Well, I know S&G may have some input and some recommendations, but S&G will work with our Attorney General on those things for those amendments to the proposed ordinance change. Yes. Okay, it's withdrawn. Thank you, Representative Willage, Dethridge. Okay, we're into the reports of committees. There's none. And now we're back to TR 2022-01, introduced by the tribal courts, a tribal resolution of the Seminole Nation of Oklahoma, reappointing the Honorable Kyle Haskins to the Seminole Nation Supreme Court. Is there a motion to that effect? We have a motion by Representative Petit. Is there a second?
Second.
I'll second that.
Second by Representative Cootie. Any discussion? I see no hands. So, Secretary, call the roll for TR 2022-01.
Leetta Sampson,
Yes.
Anthony Conley,
Yes.
John Narkemy,
Yes.
Rena Tiger,
Yes.
Anastasia Pittman,
Yes.
Terry Edwards,
Yes.
Nancy Fixico,
No.
can you repeat that?
No.
She
No.
said no.
Ida Gonzalez, Tamara Downey,
Yes.
can you repeat that?
Yes.
Okay, thank you.
Yes.
Leon Petit,
Yes.
Joseph Billy,
Yes.
Delois Harjo,
Yes.
Karen Fulbright,
Yes.
Ann Borba,
Yes.
Stephanie Lambert,
Yes.
Sina Yesla,
Yes.
Lottie Cootie, Andrea Scraper,
Yes.
Ella Coleman,
Yes.
Shirley Watkins,
Yes.
Natalie Harjo,
Yes.
Tiffany Thomas,
Yes.
Catherine McCoy,
No.
Charlie Hill,
No.
Hill, Tiffany Culling,
Yes.
Danita Harjo,
Yes.
Willis Dethridge,
Yes.
Desiree Emerton, I have a count of 23 yes, 2 no, 0 abstentions.
With a count of 22 yes, 2 no, and 0 abstentions, I declare TR 2022-01 to have passed. TR 2022-02.
Chair, could you read that vote one more time? That count, please.
The count that I heard was 23 yes, 2 no, and 0 abstentions.
Oh, sir, or chair,
You-
it's supposed to be 3 no.
Okay, can you read back the count for me?
Yes, it's 23 yes, 3 no, 0 abstentions.
Okay.
My apologies, I had the count on the no wrong.
Okay, correction. By a count of 23 yes, 3 no, and 0 abstentions, I declare TR 2022-01 to have passed. TR 2022-02, Representative Yesleth. Representative Yesleth. Representative Lambert, would you like to take the sponsor?
Can you hear me now?
Oh, we can hear you now.
Can you hear me now?
Yes, we can hear you now. Yes, we can hear you. Proceed. TR 2022-02. You're cutting out, Representative Yesleth. You were with us for a moment. Can you hear the chair, Representative Yesleth?
I can hear you. I keep getting a moderation to say if I can mute or unmute. They keep muting me.
Okay, we can hear you now.
Okay.
Okay, TR 2022-02, Representative Yesleth.
A tribal resolution of the General Council of the Seminole Nation of Oklahoma confirming the appointment of Jamie Hummingbird to the Seminole Nation Gaming Agency I make that motion and ask for a second.
I'll second.
There's a motion by Representative Yesleth, and there was a second by Representative Dethridge. Any discussion?
That was Lambert. That was Representative Lambert.
It may have been, but Representative Dethridge actually came in first. Thank you, Representative Lambert. For the second. All right, if there's no other no questions on this or discussion, Secretary, call the roll on TR 2022-02.
Leetta Sampson,
Yes.
Anthony Conley,
Yes.
John Narkemy,
Yes.
Rena Tiger,
Yes.
Anastasia Pittman,
Yes.
Terry Edwards,
Yes.
Nancy Fixico. No. Was that a no?
Yes. No.
Okay.
Yes.
I was asking
Yes.
the chair.
It is a no.
Okay. Ida Gonzalez, Tamara Downey,
Yes.
Leon Petit,
Yes.
Joseph Billy,
No.
Dolores Harjo,
No.
Karen Fulbright,
Yes.
Ann Borba,
Yes.
Stephanie Lambert,
Yes.
Tina Yesla,
Yes.
Lottie Cootie. No. Can you repeat that?
She said no.
Okay, thank you. Andrea Scraper,
No.
Ella Coleman,
Yes.
Shirley Watkins,
Yes.
Natalie Harjo,
Yes.
Tiffany Thomas,
Yes.
Catherine McCoy,
No.
Charlie Hill,
No.
Tiffany Cully,
Yes.
Danita Harjo,
Yes.
Willis Dethridge,
Yes.
Desiree Emerton, okay, I have a count of 19 yes, 7 no, 0 abstentions.
With a count of 19 yes, 7 no, 0 abstentions, I declare TR 2022-02 to have passed. TR 2022-03, a tribal resolution of the General Council of the Seminole Nation of Oklahoma, confirming the appointment of John Narkemy to the Seminole Nation Health Board and Wewoka Service Unit Health Advisory Board. Is there a motion to that effect?
I'll make a motion.
A motion by Representative Watkins. Is there a second?
A
Second by Representative Petit. If there's no discussion, Secretary, call the roll for TR 2022-03.
Leetta Sampson,
Yes.
Anthony Conley,
Yes.
John Narkemy,
Abstain?
Rena Tiger,
Yes.
Anastasia Pittman,
Yes.
Terry Edwards,
Yes.
Nancy Fixico,
No.
Ida Gonzalez, Tamara Downey,
Yes.
Leon Petit,
Yes.
Joseph Billy,
Yes.
Dolores Harjo,
Yes.
Karen Fulbright,
Yes.
Ann Borba,
Yes.
Stephanie Lambert,
Yes.
Stina Yesla,
Yes.
Lottie Cootie, Lottie Cootie.
She said no.
Okay, thank you. Andrea Scraper,
Yes.
Ella Coleman,
Yes.
Shirley Watkins,
Yes.
Natalie Harjo,
No.
Tiffany Thomas,
No.
Catherine McCoy, Catherine McCoy,
No.
Charlie Hill,
No. No.
Tiffany Cully,
Yes.
Danita Harjo, Danita Harjo,
Yes.
okay. Willis Dethridge,
No.
Desiree Emerton, okay, I have a count of 18 yes, 7 no, 1 abstention.
With a count of 18 yes and 7 no, 1 abstention, I declare TR 2022-03 to have passed. TR 2022-04. Representative from the Finance Committee.
Hello, Chair. I request to make a motion to withdraw, and not only this resolution, but also 05, 06, 07, 08, 09, and 10.
Okay, that's introduced by the Finance Committee. That's Ms. Representative Scraper.
Yes.
She's withdrawn these resolutions from 2022-04 to 2022-10. If there's no objections to that, we'll consider those resolutions withdrawn at this time.
Chair.
Representative Harjo?
Yes, this question is actually going to be directed towards Representative Scraper. Do we know when we'll be able to bring that back up?
We have been meeting every month, so our next meeting is next month. So hopefully after that, the next council meeting should be quarterly meeting.
So at the next quarterly?
Mm-hmm.
Okay, that's all I needed to know. I just wanted to, when to expect them to come back.
Chair.
Well, it's withdrawn till they come back on whatever council meeting. Right now, the quarterly meeting is the one that's scheduled.
Chair.
Representative Narkamy, you're recognized.
Just a question to Representative Scraper. This is because of there are questions about the elaboration in the, I guess the budget, lack of budget planning on these resolutions, correct?
Repeat that last sentence, Representative Narkamy.
This is, the Finance Committee is asking these be withdrawn or until a future date because of the lack of elaboration on budgetary concerns.
Well, they didn't say that. That's your words and not theirs.
Okay.
They withdrew these resolutions, and we're no longer on these resolutions. So, do you have?
Just asking. Thank you much.
Okay. All right, we're moving on to TR 2022-11. A tribal resolution of the Seminole Nation of Oklahoma approving an appropriation of the American Rescue Plan Act funds of the 2021 to the Seminole ARPA budget justification and proposed budget requests, which pertains to a compliance and planning contractual agreement with Native Advisory, who is headed by Miss Lacey Horn, the former treasurer for the Cherokee Nation, who has Native Advisory along with some of her colleagues as well. Assistant Chief Palmer, are you on with us today? I seen you earlier. Are you still with us?
I am still here, yes.
Okay, I see you now. Representative Deathridge, you're recognized.
Yes, sir. If you're looking for a sponsor for this, I'll sponsor it and ask for a second just so we can get this started and have a conversation about it.
Is that a motion to that effect? There's a motion for TR 2022-11 by Representative Deathridge. There's a second by Representative Cootie. Is that correct? Okay. No, there's a motion on the floor and a second. We're in discussion.
Chair,
Representative Watkins.
I have some questions concerning this.
Yes, you're recognized.
I would like to know, was there any bids or quotes solicited? And was there a written scope of work of the 1 month of service? And will there or is there a contract in place in the remaining balance? I didn't see anything attached on the justification that was submitted. And when we computed according to this attachment, I couldn't come up with the money amount, from like the $22,650, the $10,000 a month. It just didn't compute for the $86,400.
During this time, Assistant Chief Palmer was dealing with this firm. It did go through procurement as far as within a pandemic or emergency state of emergency, and does fit within that as far as a contract. The existing contract to lead us up to the public meeting and to steer some of the suggestions that were taken from the band chiefs over the last, I would say, 7 months or so when they were meeting, as well as some of the things that were shared at the public meeting as far as compliance issues, whether they would fit some of those suggestions and recommendations. We do have an affirmation of what does not fit within the American Rescue Plan Act under the guidelines and regulations of the final rule in the last few days. We do have those things. We are under contract at this time in the area of Phase 1, which will only take us up to January 31st. If the council was not to approve this today, that contract would expire. There's a Phase 2 of this contract, which actually deals with the motion that's presented today, and that is the compliance strategies for remaining ARPA funding February 1st through June the 30th. Phase 1 services will begin immediately upon the first payment, which I'll just explain what Phase 1 was. Phase 2 services will be enacted at the January meeting of the Tribal Council and continue through June 30th, 2022. And in the actual contract, if it's not approved by the General Council today, that contract goes away when we have no longer a contract with Native Advisory. And the total was $86,400. for that total. And the original talks with Native Advisory, the amount was $12,650, I believe, for the first phase. And obviously that came out of our executive contractual budget. We didn't have that much there, so they lowered that to what we could do at the time leading up to the public meeting. So that was $10,000, which is within the means of the chief to be able to do such a contract. So basically, the total will be $86,400 over the duration if this was to pass today. If it does not pass today, then basically it just goes away. I saw Representative Coleman's hand first, and then Representative Dethridge.
Mr. Chair, with regards to the figures that we have before us, that 86,400, noted that the payment of 22,650 and then 5 payments of 10,000 apiece is 72,650. So that leaves a balance of 13,750. And so you're saying that the 10,000 of the 13,750 it has been utilized for this first month's payment?
It has been to be able to have the contract in that first phase. Yes, it was approved. As if this contract is not approved today, then basically that will exhaust the contractual line item for executive office. But obviously, under the regulations, it could possibly be reimbursed to the executive office out of that total that's recommended. Not to say that the council is going to pass it one way or the other, but obviously that could take place, and we spoke with our CPAs on this matter as well.
So what about that 3,750? If the 10,000 is of that 13,750 is going to the payment of that 3,750, how is that going to be utilized?
When this was being sent out to the council, I don't know how many knew this, but I was in quarantine at the time, and I had related that those things be corrected with the total amount of the contract and the duration of the contract on the council portal, not to the council secretary. It's not her fault that was not adjusted. It just did not get done. Had I been in the office during this time, I would have noted that. And most of you know what I've gone through the last 2 weeks, and some of you may not. But Assistant Chief Palmer was the lead on this at the time. And if he has any comments, Assistant Chief Palmer, you have any comments?
Yes, I do. Representative Coleman, it's basically a simple typo mistake. I did request that our budget officer make a correction to that, and in the correction it didn't exactly translate onto paper correctly, so it's just a simple typo. So the first payment that we executed, as Chief alluded to, through the end of this month was for 10,000, and so the balance would simply be the difference of that original contract. I believe was 86,400. It's either 86,000 or 84,000.
So
Okay, the total is $86,400, and you subtract the 10,000 from that, that's 76,400. And
That's correct.
and then you deduct another 50,000 from that, that's 26,400, and then you have 22,650 payment. You still have a balance there. That's what we were trying to clarify, you know. There's another remaining balance there. That $10,000 doesn't absorb that total 86,400.
And that's simply because it was not corrected correctly on that packet.
Chair.
Representative Dethridge?
Ms. Fixco had her hand up, sir, and then me.
Oh, I'm sorry, Representative Fixico. Representative Fixico?
My band didn't have this information, and because of the lack of information, they wanted me to table it, and I know we have to have it passed today. And that's what my direction was supposed to be done, was to table it because we didn't have the information. We were lacking it, so they decided to tell me, so that's for a table. But, you know.
That's understandable, Representative Fixico. So there's a motion to table by Representative Fixico of this resolution. Is there a second? There's a second by Representative Cootie. So we're on the table. And there's no discussion on a table. So if you want to address this today, then you vote accordingly on this table. So this is a motion to table TR 2022-11, which is the consultant agreement for compliance and planning for ARPA. Secretary, call the roll.
Leetta Sampson?
Yes.
Anthony Conley? Anthony Conley? John Narkemy?
Yes to table.
Raina Tiger?
Yes.
Anastasia Pittman?
Yes.
Terry Edward?
Yes.
Nancy Fixico? Ida Gonzalez? Tamara Downey?
Yes.
Leon Petit?
Yes.
Joseph Billy?
Yes.
Delois Harjo?
Yes.
Karen Fulbright?
Yes.
Ann Borba?
Yes.
Stephanie Lambert?
No.
Sina Yesla?
No.
Lottie Cootie? Andrea Scraper?
Yes.
Ella Coleman?
No.
Shirley Watkins?
No.
Natalie Harjo? Natalie Harjo?
No.
Okay. Tiffany Thomas?
No.
Catherine McCoy?
Yes.
Charlie Hill?
Yes.
Tiffany Cully?
Yes.
Danita Harjo?
Yes.
Willis Dethridge?
No.
Willis Dethridge?
No.
Desiree Emerton? Okay. I have a count of 18 yes, 7 no, 0 abstentions.
Okay, with a count of 18 yes, 7 no, 0 abstentions, I declare 2022-11 to have been tabled. TR 2022-12,
Chair, Chair,
Representative Fulbright.
yes, on this, I want to go back to 2022-11.
It's
On
been-
this
it's-
table, are we tabling this until February? And can it be picked back up? This contract?
When it's tabled, it comes back at the next meeting.
Okay, so then, will we have the opportunity to still use this, native advisory? at that
Well, you
time?
know, that'll be up to them if they want to deal with us as a Seminole Nation, you know, after this has been tabled. But, you know, right now, I think, you know, we can't really discuss a tabled item, but we'll see where that goes, you know. But
Well,
I
I
can't
mean,
give you
why bring it
I
up
can't
at the
give you a
next meeting
definite
if they're
answer
not
on that
willing
right
to-
now. Okay,
I
we're
mean,
back
why
to
bring it up?
It will come back at the next meeting.
Okay.
Yes.
Got it.
TR 2022-12, a tribal resolution of the Seminole Nation of Oklahoma repealing TR 2018-07, assigning all rights excluding ownership and obligations in and to the Seminole Nation owned property located at 4th and Oak Streets in Seminole, Oklahoma, to the Seminole Nation Division of Commerce. Now, what this is actually doing is repealing that original resolution, and the standard is that if there was an announcement and the governing body knew that this was coming up, and that was done with the agenda that was set and sent out to the council within the 10 days, then the majority of the count would repeal it. So do we have a motion to that effect?
Chair, I'll make that motion.
There's a motion, TR 2022-12. Is there a second?
Second.
And who was that? I'm sorry.
Ann Borba?
Repeat that again, I'm sorry.
Ann Borba?
Oh, Representative Borba?
Yes.
Okay, we're in discussion. Representative Fixico, you're recognized.
Chair, again, the band told me to table this because of information. You know, so there's always a confusion there, but still, they wanted me to table this one also.
Well, you know, there's no second on that table at this moment, so it's not a tabled item yet. I just want to tell you, since 2018, it was passed. There was a rural business development grant originally at the Grisso that was dealt with in the case of this particular building to be transferred to be able to take those funds and utilize them for retrofitting of this building. Okay, and then Seminole LLC, which is one of our LLCs, was to take over that building. Within the USDA, if they were going to use those funds for retrofitting that building, they were going to actually require a 10-year period of time that the LLC existed in that facility. Somewhere along the line, because of the adjustments with USDA, there was a thought to use it for a different purpose, but still retrofit it with USDA funds. There was two individuals, and I'm not going to name their name, but they were tribal employees at the time, that said that would not be proper because the agency's already approved it for this purpose, and you can't do those kind of things. And it needs to go back to the tribal council. So this was back in the last administration. So it never came back to the tribal council. Those funds were never spent on this building. So therefore, we're looking at ATG Cares money to be appropriated to retrofit this building. And if this was to pass, if this wasn't not to be repealed, then the Seminole Nation is repairing this building there, and then we still have ownership and responsibility for it, but all the rights would be with the SNDA. Not SNDA, but Division of Commerce. Therefore, then they would turn around and charge us for space for that building. The Seminole Nation purchased this building for approximately $140,000 many years ago, maybe around 2016 or whenever it was. So that's the status we're in at this point. They didn't do anything with it we're in 2022 now. This passed in 2018.
Chair,
Yes.
point of information, this is Representative Harjo. Did this table receive a second?
No.
Then I would like to entertain a motion to approve this resolution of the Seminole Nation of Oklahoma repealing the 1807, assigning all the rights excluding ownership and obligations in and to the Seminole Nation owned property located at 4th Streets in Seminole, Oklahoma, to the Seminole Nation Division of Commerce, and I ask for a second.
second.
Thank you for that. There's already a motion and a second on the floor. I just wanted to explain since we was in discussion. So there is a motion on the floor because there wasn't a second on the table. If there's no other discussion, then we're going to the question. Secretary?
For question.
I had a question.
Representative Narkamy, you're recognized.
Yes. I understand everything you've just said, but the question still begs to be answered. Are we in a... I know this was assigned to SINDOC originally, and we're making a motion to assume it back to the Seminole Nation. Are we in a position to accept that responsibility?
If we weren't, it wouldn't be coming to you today.
That's not an answer.
I have a question as well.
Representative Lambert?
Yeah, my band wanted to ask if we could do a friendly amendment and remove the $5,000 returning to SINDOC.
Repeat what you just said.
My band was asking if we could make a friendly amendment to this resolution and remove the $5,000 returning to SINDOC, but not making the $5,000 payment to SINDOC, but approving the transfer.
I don't think that the council even knows what you're speaking about, Representative Lambert. I know what you're referring to. SINDOC is want to have a reimbursement of some mops and some masks and some other things. I guess that they went in and cleaned the place up or something. And I don't think the total is $5,000. I don't know where you got that figure, but it was closer to around $3,000 they said they had spent on that.
Okay. Or removing the amount of money returning to SINDOC is what they wanted to do.
Okay, well, if you want to put that on as a friendly amendment, these are supposed expenses that was done on that building by the Division of Commerce, and we did get a note from the CEO from the Division of Commerce that suggested we reimburse it, but she's asking that it be waived, any reimbursement that they may ask for by this tribal council. That's her friendly amendment. There was a first, and was there a second to that? And would you accept that friendly amendment?
I will second that amendment.
The sponsor, which is Mr. Dethridge, and who was the other? Representative Borba. Do y'all accept that friendly amendment? She said there's been some supposed that they want the nation to reimburse them of supplies or something they use to go do some things to that building. Not construction, sweeping up, doing different things of that nature.
I'm concerned about that. $5,000 that just come out of the air. I mean, we could have said 3,500 maybe. I don't know. So my answer is no to the friendly amendment.
Well, you're going to force us as the executive department then to tell them no anyway, because, hey, we're just giving them a $140,000 building. We supported SINDOC for the last 20 years for nearly $500,000 a year until they got the lease. We continue to do that in certain capacities as a nation, and I find it offensive for them to ask us to reimburse them for those supplies that they're asking of. So that would have gave us some support if you accepted that. But Representative Coleman.
Mr. Chair, the rest of us didn't know, when our band didn't know anything about that. Any correspondence from SINDOC? So even after we take action on this, we would like to have a copy of that just for our records. I mean, we're not
Yeah, you
gonna...
can have a copy of that, but at this time, executive isn't planning on reimbursing them for their supplies, paper towels or whatever it might be at this point. But we will we'll address it at executive level. It would be good for the council to support it, but you're not going to accept it, are you?
Chair?
Why not?
Representative Dethridge.
Let's go. I will.
You will accept it? Yes. Okay, it's accepted, that friendly amendment. Whatever the costs are, we'll send it out. Matter of fact, we'll send it out maybe before the weekend's over to you as the council. Okay.
Chair?
Yes.
You know, I'm thinking that we're supposed to be, you know, taking care of the nation's money. They had that building for several years, and anyone knows, you know, simple supplies is what you do if you're going to clean up a building. I don't feel like the tribe should reimburse them because we have already supported them in many ways, so I don't think that's necessary to reimburse them.
Well, you're the other sponsor on this as far as the motion was concerned. So it's accepted to not pay them then. That was what the friendly amendment was about.
Sounds good.
So y'all accept that. Okay. This is for TR 2022-12. And this is to repeal it along with a friendly amendment not to reimburse the Division of Commerce for those expenses. It's more closer to $3,600, somewhere around there. But we'll send it out to the council. Okay, does everyone understand? Okay, Secretary. Secretary, call the roll.
Leetta Sampson? Leetta Sampson?
Yes. Yes.
Anthony Conley?
Yes.
John Narkamy?
Yes.
Rena Tiger?
Yes.
Anastasia Pittman?
Yes.
Terry Edwards?
Yes.
Nancy Fixico?
Yeah.
Tamara Downey?
Yes.
Leon Petit?
Yes.
Joseph Billy?
Yes.
Delois Harjo?
Yes.
Karen Fulbright? Karen Fulbright?
Yes.
Ann Borba?
Yes.
Stephanie Lambert?
Yes.
Zena Yesla?
Yes.
Lottie Cootie? Yes. Andrea Scraper?
Yes.
Ella Coleman?
Yes.
Shirley Watkins?
Yes.
Natalie Harjo?
Yes.
Tiffany Thomas?
Yes.
Catherine McCoy.
No.
Charlie Hill.
No.
Tiffany Cully.
Yes.
Danita Harjo.
Yes.
Willis Dethridge.
Yes.
Desiree Emerton. I have a count of 24 yes, 2 no, 0 abstentions.
With a count of 24 yes, 2 no, 0 abstentions, I declare TR 2022-12 with amendments to have passed. Now, there's a couple of announcements before someone calls for adjournment. Representative Dethridge.
Yes, sir. Some of you may have forgotten, but I'm on the BCR Commission. It's the Business Corporate Regulatory Commission, along with Ella Coleman and several others, Stephanie Lambert. But I need to read this about our employees. We have 5 employees at the BCR, that little building just behind us. We are right now is established to bring, it says the BCR building where we are right now is estimating to bring into the Seminole Nation's economy $2.7 million this fiscal year. The BCR had its first COVID outbreak on January the 4th. 2 days prior to that, one of our employees lost a close relative who passed away. A third and fourth of our employees were ill, but not with the COVID, and continued to perform all of the duties the job required. Then another came down with COVID. All in all, from January the 4th through January the 24th, our doors remained open and customers were served. I just wanted everybody here and listening that we do have some very good and loyal employees, and 5 of them work for the Business and Corporate Regulatory Commission. So I just wanted to commend our employees.
That could go for many of the departments of the Seminole Nation. Everybody understands that we're in a very high spike of the present variants of the virus. And there's many people that have relatives and friends and extended family that have passed on as well and work as they can. So that could go to many of the employees of the nation. We do appreciate everyone's vigilance, including this tribal council, during this difficult time that we're experiencing here in the United States and around the world. I see Representative Harjo, and then I see Representative Cootie. Representative Harjo.
Yes, I just, Chair, I also will kind of piggyback to that. The lawsuit band does appreciate all the tribal employees for everything that they've done because of how terrible the variant has been and how aggressive it's been. That being said, is knowing that I work for the Tribal Epidemiology Center for Southern Plains Tribal Health Board.
Yeah, Representative, your connection is veering in and out.
Hang on a second. I think I accidentally muted myself. Can you hear me now?
Yes, the last thing we heard was you work for the
Southern Plains Tribal Health Board for the Tribal Epidemiology Center. And that being said, is I want to share in the chat a website that we can go to that you can actually, you're eligible to go and order free at-home tests. And it's at www.covidtest.gov. And you're eligible for up to 4 free tests every household in Oklahoma.
Okay. If you could send that information to the council secretary, we can then we can put it on the website as well. We appreciate that. We appreciate that announcement. Now we're in announcements now, And it's not on the agenda, but I gave you the courtesy. I'm going to give Representative Cootie the courtesy as well. Representative Cootie? Look at there, boy. She's still married. All right. No further business. We're going to pray after adjournment, but anyone make that motion to adjourn?
I'd like to at least say something about Head Start. Have y'all been hearing about Head Start? I made some visits with 2 centers. They really need some help. This building over here is all tore up. One room is almost finished, but they've been working on it a while. And they need some help with IT. There's no communication over there. There's various things they need help with. And I'll talk with you about it later, Chief. And then we will, there's so many things that's over there that needs help. I'm just trying to help them out here because it's so far behind, and we're trying to stay in compliance with the funds and the programs and et cetera. But I got phone calls about it. So I just went ahead and made a visit and talked with them and see what was what. But they do need a lot of help. I just wanted to get some help for them, to help them move along and progress. But they really need help. I just want to throw that at you, Chief, because I told them I'd help them out in the matter they need. And I'll get back with you on some more issues. And I just want to share that with you right now. So, the schools have a little problems, and we got to help them fix it. Mado.
Yeah, since that subject matter came up, that is under a contract for insurance claims. So it's an ongoing process. Obviously, materials at times do not come in as fast as you would like them to, especially during this pandemic. But we'll leave it at that. And we communicate with Head Start on a regular basis. And this is the first time I heard that about their IT problems, but I will check into that Monday. Thank you for bringing those comments forward. Okay, do we have a motion to adjourn? Motion to adjourn by second. If there's no objection to adjourning, we're going to have prayer, and then we'll consider ourselves adjourned. Representative Coleman, could you close us out in prayer, please?
Be glad to. Zagady the light of God surrounds us. The love of God enfolds us. The power of God protects us. The presence of God watches over us. Wherever we are, God is. We thank you, God, for being with us today in this council house and in the virtual environment, and helping us to speak with knowledge and make decisions with wisdom, Heavenly Father. We thank thee for healing our chief, Heavenly Father, so he could be here with us today. And we ask that thou will continue to give him the strength, and others the strength that have had COVID, Heavenly Father. And those that have been tested positive, I ask that their symptoms will be light, their recovery be rapid, and that they have a full recovery, Heavenly Father. And bless our new Attorney General and the staff, Heavenly Father, and that we will all work together as we move forward in the best interest of Seminole Nation. In Jesus' holy name I pray. Amen.
Amen. We're considered adjourned. Thank you, General Counsel.
Thank you, Chief.
Next meeting.
What?
Did you want to say something?
No. Well, I mean, thank you to everybody, but are you okay? I didn't realize you were sick.
I was. I had passed my 2-week period since having it. I don't have any symptoms except a little bit tired, and that's about it.
Thank you so much. Thank you.
We put this shield in. Valerie, you should have sat on that side.
Thank you so much. Thank you. Chief, are you ready for your meeting with Langford?
Yeah, I believe we're